Hi, this is Erica Merrill, and I'm the founder of Perfect Legal Video. And I'm very excited to bring to you today attorney Jim Sorenson from the Sorenson Van Leuven law firm out of Tallahassee, Florida. And Jim, welcome. We are so excited to have you.
Thank you, Erica. I'm excited to be here today. Excited to talk with you.
Great. Now, you and your law firm represent credit unions. So it's really to make sure that credit unions are working at their best capacity and following the rules so that mistakes don't cost them hundreds of thousands or maybe even millions of dollars. Is that right?
Yes, we work with our clients, with our credit union clients to help them comply with the law, to help them operate efficiently and without extra cost. That's really our focus, is to help them be efficient and to do everything within the letter of the law.
And I think that's fantastic. So I personally have met a lot of your clients and filmed video testimonials. So I know that they all are over the moon about you and your work and your law firm. You have a large team that helps you accomplish, what you've accomplished so far. So I think that is fantastic, and it speaks volumes about you and your firm.
Well, thank you. We are very blessed to have the clients we represent and we get to work with every day.
You're welcome. So today we're going to be talking about a really interesting topic, as usual. We're going to be talking about towing and mechanical liens on motor vehicles. And so let's talk about how this issue will impact a credit union.
Yes. So credit unions, by nature, credit unions, one of their largest portfolios is auto loans. That's for most credit unions, that is where their bread and butter happens. That's where their main loan activity happens, is in auto lending. They do other types of loans. They do mortgages and credit cards and other types of loans. But for most credit unions, their largest number of loans is auto loans. And this issue goes directly to that. So for a credit union, their concern obviously is the collateral that secures that loan, the autos that secure that loan. So when a credit union makes an auto loan, they take a lien on the automobile or the motor vehicle, and that lien is put on that vehicle to secure that loan, so that if the borrower stops paying, they have recourse to be able to go and repossess the car, sell it, and limit or at least reduce their potential losses. And the issue with these mechanics and towing liens is this is a situation where a third party is able to, or may be able to, get a lien on the car, and that lien would trump or be superior to the credit union's lien, which at the end of the day means that if that lien is not satisfied, the garage or the towing company could sell the car and the credit union loses its collateral. If the borrower stops paying, they have limited recourse. So this is a big issue for credit unions, and we see a lot of questions on towing and mechanics liens, repair liens on motor vehicles.
Wow, I mean, that's interesting. I hadn't even thought about somebody else's lien being more important than the credit union itself who gave them the loan. I'm terrible. But I'm glad they have you to walk them through it. Now, how often do clients have to deal with these types of liens?
Well, for most clients, this is something that happens on a regular basis. They get lien notices on a regular basis. Now, of course, it will vary from client to client. The larger the client, the larger their number of auto loans they have on the books, the more often this happens. So, I have some clients, they get these notices almost daily. And I have other clients that may get one a week, or, one every other week. So, it does depend, but it is something they see quite often. And what we see is we see this to be also somewhat geographical. Our clients in South and Central Florida see it more often than our clients in North Florida.
Wow, that's amazing. So why do you think that is?
Well, I think there's two reasons. One is there's more people living in South Florida or South and Central Florida. So because you have a larger population, more auto loans, you're just going to see more of these things. But I think there's a secondary reason, and we see this play out quite often. There seems to be, for whatever reason, just a disproportionate amount of fraud that comes from South Florida. And so we see a lot of these liens involved in some sort of fraudulent scheme, and there's more of those in South Florida than anywhere else in the state.
So that's where all the troublemakers live.
I guess so. I guess so. I'm not sure why that's the case, but that is something that we continue to see and have seen for a while.
Well, South Florida has a reputation for being really fun. So, so how are these loans fraudulent?
So, well, the what we see is different schemes involving these liens where there's fraud involved. And so, for example, I mean, we could take an hour and talk about all the different scams and schemes that are out there. But for example, we have seen where you have a borrower who is having trouble paying their loan, and they're worried about losing their car, and they find a person who may or may not own a garage, may be pretending to be a garage, and they say, hey, I'll help you get your car from the credit union or from the lender. I'll help you get that car. You won't have to pay your lender anymore. And so what they do is they create a fake lien. A fake repair was done on this vehicle, and it is for $5,000. And they send a lien notice to the financial institution that holds that lien on the car. And if the financial institution doesn't act, that car gets sold and magically gets retitled in the name of, your borrower. And of course, the garage gets some money out of the deal, but the borrower gets the car free and clear. Or the car gets sold to a third party, and the borrower and the garage split the sale of the car, with the lender, the financial institution, not getting any money. So those are some of the schemes that we'll see. We also see where just unscrupulous garages and towing agencies will create or add to a lien charges that aren't real, that aren't documented. They'll say, we did these repairs, or we towed it this far, when that in fact isn't what happened, and they're just inflating their bill to make more money. It's basic greed, and that's what underlines any of these fraud schemes.
Well, I'll tell you, that's why I buy new. It's true. Like, sometimes a used car can cost a lot more, but when they are, having fraudulent activities, then it gets worse. So, is there any protection for your clients in this case?
Yeah, so and we're talking about Florida law here, and so in Florida, the law changed last year. Last year, the legislature passed a new law, or changed to the existing laws involving towing liens and repair shop liens, and that law went into effect January 1 of 2020. And while that law has some good changes, and I think they're helpful, and so far they seem to be helping, in my opinion, as an advocate for credit unions and financial institutions, it didn't go far enough. But some of the changes, just to give you two real quick, one of the changes was it does limit what the lien or the entity claiming a lien, what they can charge for what's called administrative fees and costs. What we would see in the past was we would see these liens come in where they did $3,000 worth of repair on the vehicle, and then there's another $700 in administrative fees and costs added to it. And so what the new law says is those fees and costs cannot exceed $250, no matter what. So that was good, because in the past there was no legal cap, and anybody could put a figure on there, and if you didn't like it, you were either stuck paying it or going to court and challenging it. The other thing that the law did that I think is helpful is to make it clear that the lender, the financial institution, has a right to inspect the vehicle. They have a right to see the vehicle, confirm what condition it is before they fork over $3,000. And So those are two big changes. There's other changes, and if anybody listening to this interview wants more information on that, I did a newsletter article for our firm back in December of 2019. That is on our website. So if someone goes to our website, goes to the news section, they can find that newsletter article and read everything that law changed.
I mean, I think that's fantastic, and you guys are the best at keeping your clients and everyone else up to date on the changes in the law. And you know, these things happen fast and furious. And not to do another car pun here, um, but it's true. And so it's very important to keep on top of that. And it sounds like they've seen the problem and they're starting to make some changes to help the credit unions. So that's great. Now, are there red flags so that the credit unions can kind of see this coming?
Yes, I do believe there are red flags that would give you the idea that there's potential fraud involved. None of these are by themselves 100% accurate, but they're red flags. They simply something that if we see it, what we're telling our clients and what we're trying to help our clients understand is those are things you need to take a deeper look at. Those are things you need to investigate further. So to me, the potential red flags involving tow and repair liens are one, it would be where there's a large repair bill on an older model vehicle and the borrower has had trouble paying that auto loan on time. So your borrower has been delinquent, been paying late, and all of a sudden the car is taken to a shop and supposedly a new engine is put in the car. That usually is a red flag. People who are having trouble paying their bills don't put a new motor in their car. So typically, if they can't pay their auto loan and the engine goes, they just walk away from the car. So that's a red flag. Repairs totaling more than 50% of the vehicle's value. That's another red flag that I would say you want to look for. When a garage refuses to allow the lender to inspect the car, or makes it really hard for the lender to inspect the car, that is a red flag. The repair or towing lien comes from a city that is not close to your borrower's residential address. It is true from time to time people travel and they have car problems and their car breaks down and they've got to take it to a garage out of state or out of their local area. But those are rare and those are the exceptions. And what we'll see is, oh yeah, the borrower brought this car 300 miles to this garage in another city to have engine work done. That's a red flag. And then I think another red flag is where your borrower has been cooperating with you. They've been in communication with you. They've been talking to you, and all of a sudden they go silent. That can be a red flag. And then lastly, and this is something that we see more often now, surprisingly, is garages or towing companies that only will accept cash for satisfaction of the lien. They don't want to check, they won't give records, they won't give receipts, they want cash. Reputable businesses will accept cash obviously, but they're also going to accept a check. And when a credit union or a financial institution, a bank or a credit union issues a check, it is a cashier's check. It's just like a cashier's check. So their refusal to accept that usually indicates something underhanded is happening. It may be tax evasion, or it may be more directly fraud involving the car itself.
So what are the actions that the lenders should take if they see any of these red flags?
Yeah, well, I think, the actions that a lender should take is, and this is true with regards to any lien notice, they need to act quickly. what we find is often these lien notices come in, and they come in certified mail. That's how it works in Florida. They have to be sent certified mail to the lien holder. And that address is based upon the address that is registered with the Department of Highway Safety Motor Vehicles. So your address on the lien, that's on the certificate of title to the vehicle, is where that notice is sent. And that notice comes in and it sits on someone's desk. Maybe, it's supposed to go to Susie, and Susie's on vacation this week. So it sits on her desk, and when Susie gets back, she's got a lot of work and she doesn't get to it for another week. And then by the time she gets to it, 2 weeks have run, and now we're down to a week before the vehicle is going to be sold to satisfy that towing or repair lien. That can be a problem because it limits your options. You have less time to investigate, less time to potentially have the car inspected. So that is, act quickly is probably number one. Two is just simply look for the fraud, look for your red flags of fraud, and investigate accordingly. Try to reach out to the borrower, try to reach out to the co-borrower on the loan. Find out, did they take it to the garage? Did they authorize the repair? And then if the bill is large enough, in other words, if the towing lien or repair bill is large enough to justify the expense, go out and inspect the collateral. I have had clients who have paid large repair bills for replacing an engine in a car. And I remember this situation vividly. Client paid, I want to say it was about $4,000 to a garage that supposedly replaced an engine in a very nice European car. I don't recall if it was a BMW or a Mercedes, but it was one of those. And when the repo agent went out there to pick up the car after paying the lien, the engine to the car is sitting in the front seat of the car. It's not in the car. And this garage was basically operated out of a person's garage. It wasn't, it was a friend of this person using their garage to run this garage. And the person who got the check disappeared. And the credit union was without recourse in that situation. And had they inspected the car before they delivered the $4,000, they would have avoided that mistake. So those to me are the three things: act quickly, look for the fraud signs and investigate, and then when the dollars justify it, spend the money to have the car inspected to make sure that the work that was supposedly done was actually done.
Well, you're definitely protecting your investment if you can take those actions. So, I mean, I think those are really good suggestions. What can they do to stop the sale of a vehicle by the towing company or the garage?
Yeah, so under Florida law, there are two options. One is they can post a bond with the court. So if the sale of the vehicle is supposed to take place in a particular county, that's the county where you would go and to the court, and you would post a bond. So the bond is the dollar amount of the lien. So if the garage is claiming that they're owed $4,000, the lender who has a lien on the car would have to go and place a $4,000 bond with the court. That results in an order to stop the sale. And then there's a process by which the garage has to go through to prove their lien. In order to, if they prove their lien, they get the bond money. But in the meantime, the sale is stopped and the credit union gets the car. The alternative to that is you can, instead of a bond, we can file an action in court, in state court, to stop the sale and basically have the judge decide, is it a valid lien? Is there money owed? And if so, then the credit union is going to have to pay that. Both of those actions cost money. The bond is generally the cheaper route, but there are some times where filing the legal action makes more sense than the other.
Well, that is really great information, and I feel like credit unions watching this interview are going to have a much better handle on how to deal with the situation with the garage and the towing companies. So, are there any parting words that you have on this topic?
Yes, I think that the two final words are, one, credit unions need to educate their staff. They need to educate the people who receive these notices and handle these notices. Typically, that's in the collection department. they need to educate them on what the law is and what the red flags are and how to go about investigating this. And then two, the credit union needs to have a good procedure in place, a procedure or a written process that guides their employees on how to deal with this. This is something that we do, our firm does. We work with clients to develop a good written process and procedure to deal with this, and then help our clients train their employees on this so that money is not lost. Things are happening quickly, and we obviously, when needed, we get involved representing our clients in challenging fraudulent liens. But really, what we want to do is help our clients on the front end handle this in a timely fashion. And there's a lot of things they can do on their own with the right training and the right processes.
Wow, I mean, I think this is fantastic. Thank you so much for joining us again this week, Jim. I know how busy you are, and we really appreciate the information. I hope you have a wonderful weekend, and I hope everybody watching has enjoyed the show and will use this information accordingly. Thanks again. Have a great weekend.
Thank you, Erica.